I'm Lynsey Harrison, and I'm the head of Clarine's Contentious Private Client team. And I'm here today to have another conversation with one of the team. Today, we're going to be discussing a really critical topic in relation to inheritance disputes, and that's what happens if a spouse has been left out of a will or receives an unfair share. What can they do? And joining me today to look at this topic is Sam, who's a solicitor in the team. Hi, Sam.
Hi.
Let's start with the basics. What is the Inheritance Provision for Family and Dependants Act 1975?
Okay, that's a good question. The Inheritance Act, as we call it, allows certain people, including spouses, to challenge a will or intestacy if they haven't been adequately provided for. So the law is designed to prevent financial hardship and to ensure fairness in inheritance disputes.
So who exactly can take a claim under the Act?
So the Act covers a range of claimants, including spouses, civil partners, children, cohabitants and dependents who were financially supported by the deceased. But today we're going to focus specifically on spouses and civil partners. They've got unique protections under the law.
Okay, so when a surviving spouse makes a claim, what does the court look at when it's determining whether or not a financial provision has been made and is reasonable?
So there's a wide range of factors that are considered by the court, and these are things such as the applicant's financial needs, and that's now and in the future. The court will look at the size and nature of the estate and also the needs of other beneficiaries. They'll also consider what were the deceased obligations and responsibilities towards the applicant. And one thing that we are going to look at in a bit more detail now is that for spouses and civil partners, there's an enhanced test that the court would consider as well.
So let's look at that special enhanced test. How does that differ from the standard test for other claimants?
Okay, so this is where it does actually get really important for spouses. So for most claimants, the court will only consider what is reasonable for their financial maintenance. But for spouses and civil partners, the court applies a test that goes beyond this, and it's a two-part test. So they will consider what is reasonable in all the circumstances of the case. So looking at the lifestyle, the standard of living that the spouse had before the deceased passed away. And then they'll also consider something that's called the divorce standard test. So in a spousal claim with the divorce standard test, the court would consider and look at what would that spouse have received had the marriage ended on divorce rather than death.
Oh, so that could make a substantial difference to a claim.
Yeah, absolutely, because what we're doing is not just looking at what is required for their financial maintenance, it could significantly increase what they would receive in terms of an award.
And is there a time limit for taking that type of claim?
So any claim under the Inheritance Act, whether that's for spouses, civil partners or other claimants, there's a 6-month time period, and that's from the date that the grant of probate was extracted.
Mm-hmm. I'm guessing if you're not a specialist in this type of law, that's a really easy deadline to miss because it's so short compared to normal litigation deadlines.
Absolutely. And, if you go beyond that, there is scope to apply to the court and ask for permission to bring a claim out of time. But obviously that's more difficult. The ideal is to make sure that you're dealing with it in the time period.
Absolutely. And have you got an example of a recent case where you've acted on something like this?
I have. As it happens. So I recently acted for a spouse in a Inheritance Act claim. This claim was settled at mediation rather than trial. So we find a lot of these types of cases will settle at mediation rather than going to a final hearing. We made some really successful arguments on behalf of our client, and that allowed us to secure almost half of the estate for him, which was a really good result.
So why didn't the deceased leave his spouse anything?
So in that case, the deceased, our client's wife, left everything to Battersea Cats and Dogs Home. So her estate was worth just over £1.2 million. Quite a sad story, really. The deceased suffered with alcoholism and towards the end of her life was becoming quite confused, suffering with delusions, felt that her husband's intervention to help her with her addiction meant that he didn't love her anymore. And as such, she just wrote him out of the will and left everything to the charity.
That's really sad. And I mean, how did the charities involved respond in the initial stages?
It was quite difficult, really. I can see it from their viewpoint. Charities rely on legacies from wills to keep them going, and obviously this was a significant size of a legacy. The arguments they tried to put forward were that my client and the deceased were only married for a period of 4 years. But what's quite interesting in a spousal claim like this is that a court will look at not just the length of the marriage, but the length of the relationship. And actually, in this case, they'd been together for nearly 18 years before they were married. So we were able to successfully argue that actually it was the entire length of the relationship that would be taken into account by the court.
And did they make any other argument?
They did. They said that the divorce cross-check shouldn't be taken into account. So the divorce test that I talked about earlier, the issue here was that my client had his own house, and that him and the deceased lived apart for most of the week, and they would just see each other on weekends, despite being married.
I mean, some people might say that sounds pretty good.
Agreed. And the thing with this is that case law, is quite clear that just because a marriage from the outside looking in might not appear conventional to some, it worked for them. And obviously it worked for a significant amount of time, 22 years. So maybe that is the secret to a successful marriage, Lynsey.
And you mentioned mediation there. What is mediation? How does that work?
So mediation is a form of alternative dispute resolution. It's an alternative to go to litigated proceedings. It's designed for the parties to reach an agreement between themselves and a compromise with the assistance of a trained mediator. We do find that mediations are extremely successful if both parties enter into it in the right frame of mind. So in this area of law, it's not compulsory to attend mediation, but it's strongly encouraged by the courts. And I would say predominantly most of our cases do settle at mediation, which avoids the cost and stress of having to go to a final litigated hearing or trial.
Absolutely. So if someone believes that they have a strong claim or they have a claim under the Act, what is your advice to them?
I would say that if you're a surviving spouse, you've got strong legal protections under the Inheritance Act. If you feel like you've been unfairly left out of a will, don't assume that you just don't have any rights and that the will is the document that will be adhered to. So I would say seek legal advice as soon as possible from someone within the team, and remember to act quickly because, as we talked about earlier, you've only got 6 months in which to address the claim.
That's really good advice. Thank you ever so much for joining me today and for all of your insights.
No problem. Thanks for having me, Lyns.
And obviously, if you or any of your clients or contacts or friends or family have something like this happening to them at the moment, then do get in touch because we can help. Thank you.